And I will also share my screen. Perfect. Slideshow. I'll wait maybe 1 more minute and then I'll get started. Can everyone? I'm just checking if people can hear me because I don't know. Um, yes. Okay. Yep. Perfect. Sorry. I just don't like Zoom. It always plays up on me. Um, okay. I will get started. I know people will be joining as I speak just because there's so much to get through and I want to give you guys all the relevant information for the exam and go through an actual exam as well because I think that's probably the best practice to revise all the content. So yeah, the recording of this will also be up. So, if you need to go over anything or didn't understand anything, if I spoke too fast, hopefully I don't, you can go back and watch it as well, and I recommend that you do. Um, but yeah, so this is the revision seminar, our last sort of tutorial for criminal law. I'll just do a couple of introductory things while people are still joining. So first off, um, an acknowledgement of country. So I wish to acknowledge the people of the Kulin Nations on on whose land I join online from today, and I pay my respects to their elders, past, present, and emerging. Just a quick note on academic integrity. So, the Monash LSS condemns academic misconduct and has a zero tolerance policy for people who are found to have breached their academic integrity by misusing the educational services. So, these are provided by the LSS for you guys to revise and, to, I guess, extend your knowledge on some topics and seek that extra assistance. But ultimately, the faculty and the faculty-run tutorials are your point of reference. And if there's any inconsistency between what I say and what your tutorial teachers say or your lecturers, then you should always listen to them because they're the ones that are going to be marking your exams. That being said, I did get the highest score in this subject last year when I did it. So hopefully, I've got some good tips, but take my word, but also um, give your faculty the priority, obviously. And just lastly, these are our sponsors. So Gilbert and Tobin, Cause Chambers Westgarth, Clayton Utes, and Kingwood and Mallisons. So we thank the sponsors. All right, so let's get into it. So these are the accessible topics. I got a lot of questions when you guys all signed up to the seminar, and I haven't really done a Q&A. I've kind of just like included the answers to all of your questions in my slideshows. So I hope that's okay. If anyone has any questions at the end that I have missed, um, please let me know. But I went through all 150 questions and kind of put them in my slideshows. But I had a lot of questions on what's actually accessible. So last year for us, the mid-sem topic, which was non-fatal offences, so topic 4, was not accessible. Just because, we did a mid-sem on it and the faculty thought that we'd already been tested on it. But for you guys, it is accessible. So that's fine, I guess. Um, So basically everything's accessible, obviously, apart from topic one and two. Topic one, it's good to just know because it might be relevant in your understanding of a question, but it's not accessible. And I guess topic three, I have highlighted it, but they're not going to be like, what's the element of this crime or what's mens rea? You just need to know it because it's the foundation of all the other crimes. So yes, everything in red is accessible, and I know previously I might have said that topic four wasn't just because it wasn't our year, but it is. Okay, and these are the assignments. So you've already done the first two, and now we're just focusing on the exam, which is your first in-person law exam. I also hope the fall one went well. I know you guys finished that on Monday. So now I guess it's good with law, unless you're doing straight law, even if you're doing straight law, actually, you still only have this law exam to focus on. So you can spend all your time on it, I guess. Okay, so how this is going to work, I'm first going to go through just some general exam tips, and then we will actually go through an exam, and then I'll talk a little bit about exam day since it is your first law exam. I just want to give you a couple of tips on that as well. So, exam information, I'm sure have already been told by the faculty, but just for those that have forgotten or like haven't read it, so your exam is 2.5 hours. Um, it's worth 60% of your mark. There's three questions on this year's exam. So question one, 25 marks, question two, 20, question three, 15. It is open book, so you can bring in anything you want. You can use a second device for soft copy notes, or you can bring in your hard copy notes. And there's no reading time. I got a lot of questions on like how should I allocate my reading time? Because obviously in year 12, you've got reading time for English. There's no reading time for law exams most of the time. So everything spent, I guess, on, well, you'll need to read and plan, but you can write as well. And we'll look at that and how to do that. But just a quick note on like additional devices and stuff. Bring in whatever you like. I didn't actually have a second device last year. I just like didn't have a second laptop. So I only brought in my hard copy notes. My exam notes were 11 pages. And that's all I brought in. So I guess, yeah, you don't need like 100 pages of notes. And the other thing is, with an additional device, I'm guessing a lot of you, might be using like an old laptop or something like that. Sometimes they break down or just something happens and it's really stressful or annoying. So I would recommend, if you can, just printing your notes as well, just in case. If you're someone who's anxious, I was quite anxious for my first law exam, so I was like, I need hard like copy notes as well. But enough on that. So time management. Top tip here is obviously to use the mark allocation to guide your time and do not spend too long on any one question. There's no point having a perfect answer to question one if you're then, only going to answer half of question two and three. You're trying to rack up the marks wherever you can. Most people will not finish the exam. I would say like 90% of people don't finish the law exam, the criminal law exam. And that's due to multiple reasons. They don't break their time down or they don't have good exam notes. So many reasons. I finished with like 10 minutes to go, which was actually a lot of time to like read over my answers and everything. But this is what I recommend you guys do. So I've broken it down for you. So question one, you should spend 60 minutes on. Question two, 50 minutes on. Question three, 35 minutes on. And then reread everything, the last 5 minutes. So in those times that I've included there as well, obviously you should plan your answers for each question. So 60 minutes, maybe 5 minutes will be spent on planning for that. The reason I say to reread everything is because you're writing so fast and like a lot of people don't proofread and they're not going to take marks off for spelling and stuff like that, but if it's illegible, then obviously they can't understand what you're saying. So I do think it's worth rereading everything and just making sure it makes sense because it's so easy, even just like putting the wrong section in or something, there's so much to put in and it's very easy to get stuck on that. So yeah. And then using the mark, aiming to answer all questions. So even really brief answers or dot points, got a couple of questions on that. Yes, you're allowed to do dot points. Obviously, it's not ideal. And if you can write in full sentences, please do that. But if you're like at the end, and yeah, you really don't have time, and you still there's still a couple of things that you want to say that you've missed some elements, you can definitely do dot points. You're still going to get marks for dot points. So yeah. All right, sorry, I just got a question and went off of it. Oh my gosh. Okay, I'm so bad with Zoom. I will like look at the chat after just because I know people will have questions, but I will just look at that at the end maybe, just so we can get through everything. But yeah, I think the question was, are there mark allocations for this year? Yeah, these are the mark allocations. So I think this was what was posted by, oh, I'm going back now, by your faculty. So yeah. Okay. So planning your answers. Please spend a few minutes planning your answer before you start. It's just people go straight into it and miss really important issues. Just have a think about it as well, because like the fact scenarios are really difficult sometimes, and planning is really important. I'm sure you guys know that from VCE. Read the facts really carefully, like really, really carefully. Every single fact, most of the time, is relevant. Sometimes, the first couple of sentences are like just to set the scene, so they might not be super relevant, but everything else they include in there is relevant. Um, Also, color coding method, I've done it with the exam that we're going to go through, so you guys can actually see how it applies. But basically, what I do is I highlight everything in green that is for like the prosecution's arguments, and then everything in red that is the defense's arguments. So in a fact scenario, there's obviously going to be factors that, are mitigating and factors that are aggravating. So that just means something might point towards the person being guilty, something might point towards the person not being guilty. And so I just highlight those in red and the other ones in green. And the reason for that is then I've already kind of got my arguments there. I just need to write them up. So I think that's a good way to do it. But I will show you how I do that later on. And outline your answer with headings for each element or issue. Please use headings. The examiners have always just said it kind of, some answers just like look like a dog's breakfast. I don't know. It's really hard to understand. And they're reading through these really quickly. Like they might read your exam in 15 minutes, who knows? So you want to make sure that you've outlined for them the steps that you've gone through and make sure that, that they can see that you've gone through each issue and they can just kind of tick off. So please use subheadings and headings. So, actus reus, mens rea, defenses, or something like that. Like it doesn't need to be much. You can even use subheadings for those. So you could go actus reus, causation, voluntariness, up to you. But the more structured it is, the better the mark you will get. And if running out of time, as I just said, write your outline or bullet points for the remaining issues. So, how to approach problem questions. Obviously, we're going to do this in the practice exam, but just like a quick outline, you want a quick introduction saying what crime they would be liable for. So, um, you know, Andy might be liable for common law assault or threat to inflict serious injury, something like that. Then move on to the actus reus. So, usually causation is what's most contentious, and they love to ask questions on causation. They're obsessed with causation. So, like voluntariness, I don't think I've ever seen a question where voluntariness is a problem, like, or is something you need to even discuss or, I guess, delve into. So usually it will be causation factors race. For mens rea, you want to start from intention and work your way down. So I think a lot of people just go, oh, it's recklessness. I'm just going to go to recklessness. In a real life case, if this was being argued in court, the prosecution would always try and prove intention because that's the highest threshold, and that's what you want to prove. That's the most serious or gravest kind of element. And then they'll go down if they go, okay, intention's not made out, recklessness will be, and then negligence. So please, 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 if it's recklessness, which sometimes it is, say why it's not intention. So go, um, you know, the mens rea is either intention or recklessness. Here, intention is unlikely to be made out because blah, 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 and then go into recklessness. So I've done that in the scenarios, but just make sure you start from intention for mens rea. And then step 4 is raise any relevant jury directions. This is only relevant for sexual offences, but just really important, and it's actually what distinguishes HD responses from, speaking to your chief examiner and just when I did it as well, they said that most students don't raise jury directions because they don't have time. And yeah, I think if you want sort of those higher scores, I would definitely recommend raising those. And then step five is to consider defenses and the onus of proof. And obviously conclude tentatively. The reason I say that is because you don't want to have like a definitive conclusion. You don't want to go, I don't know, they're going to be liable for murder, because you're not a judge. Right, you know, we're first year, second year law students, and we don't know if they're going to be found liable or not. So, like, please say something like, you know, they will likely be found guilty for this offense or something like that. Make sure it's not definitive because everything can be argued both sides. Like most of the time, there's really no right answer. So, yeah, you can't make a definitive conclusion. So many questions on this. So, citing authorities in the exam. Um, there's no need for AGLC compliance, so you don't need to do footnotes or anything like that. It's just a waste of time. Um, abbreviate everything you can just to save time. As I said, most people do not finish the exam, so wherever you can kind of save time, please do. Um, so, for example, Crimes Act, you know, write just write Crimes Act, don't write the year or anything like that, or you can just write CA as well. And cases, you know, just write the identifiable name of the case. So like the example here I've got is the accused act must be substantial and operating cause of death. That's Hallett. Most of the time you can just say that and they'll understand what the case is. Yeah. Okay, so just quickly on exam preparation. Obviously, everyone's different and everyone will prepare for an exam differently, but this is how I went about it. So, firstly, I made really concise summary notes. Um, you can't have too long notes. You just will not have time to look at it as well. Like it's just going to waste your time to be referring back and forth to your notes. Um, then I turn those notes into sort of a scaffolding script. I've actually got an example of it on the next page. And the reason I did that is to save myself time. I kind of already constructed some sentences that I knew I'd use. You know going to use the sentence of, you know, the act must be the substantial and operating cause in brackets Hallett. Like, you know, if there's causation, you will raise that. So try and kind of make those sentences already because once again, you will not have time to come up with everything on the spot. And as I said, I only brought in 11 pages of notes, but it was kind of a scaffolding script. Practice questions, the best way to do it. Don't spend too long on your notes. Like actually, you know, do an exam and try out your script if you've made a script and see if you need to alter it. Um, now that you guys have finished the full exam, you sort of can do a practice question a day. They don't take too long. Even if it's not a full exam, just like one question from one exam. Yeah, I would say try and do one a day. You'll be very prepared if you do that. Study groups as well are really good for law because they don't give you answers, which is kind of annoying. But since the faculty doesn't give you answers, it's kind of hard to know like what's right, what's wrong. So if you know, come together as a group and go, oh, I spotted this issue, I spotted this issue, then you can sort of see, you know, what other alternatives there are and how other people think as well. So I think it's actually really good for law to do that, just because we don't get answers. Organise to see your lecturer and go over practice exams if you can do that as well. I don't know if, you know, your lecturers have allowed you to do that, but some of them do. And I think that's helpful. And then flowcharts and mind maps as well. I know a lot of students, I don't really do them, but a lot of students do find them helpful. It kind of just makes sense in their brain to kind of lay it out step by step. Yeah. So this was sort of this is an extract from my exam script. Feel free to take a screenshot. Please don't, you know, I've got a little note there. It's just an example. Make sure you apply it to your own specific facts. You know, don't just copy and paste as it is because they will be able to tell straight away if it's just a script. But I found this structure very helpful for saving time and organizing sort of my notes. So yeah, it's for Section 38 rape because I found it really hard because there's so many like subsections that you need to mention. So I sort of tried to construct it in a sentence, and go, okay, so this is the actus reus here. I go, the actus reus elements must be made out. It is clear that the defendant sexually penetrated the victim by, and then, I'd include the act. Um, and then include what section is relevant as well. Make sure you highlight the sections because it's so hard typing up in an exam and making sure you've got all the right sections. Um, Without consent as well, intention and no reasonable belief that B was consenting. So yeah, I just guess created sentences from my notes and make sure I had the relevant sections. Um, but I think it's a really good way to do it. But you do need to then be able to apply it to the facts because they can tell straight away if it's a script and you haven't applied it. So yeah. But yeah, feel free to take a screenshot and kind of base yours off that. Another tip to save time is to state this at the start of your exam. So this is what I did. So I said all sections mentioned refer to the Crimes Act 1958, unless otherwise stated. Be careful with that though, if you do that, because if you're talking about the Jury Directions Act, so there's only two acts in criminal law that you speak about. It's the Crimes Act and the Jury Directions Act. If you speak about the Jury Directions Act, you need to make sure then that after that you write Jury Directions Act. Because otherwise, you go section 20, section 21, it's all good, and then you get to that and you get confused. So only do that if you remember, if you're talking about a different act, to state that. I also stated, in order for the following individuals to be held criminally liable, the prosecution must prove the elements of each offence beyond reasonable doubt. And I put that in brackets as BRD. AR and MR elements must occur contemporaneously, and that's from Fagan, or Thabo and Melly. So, once again, the reason to state that is because, like, you don't want to be repeating that after each offense. This must occur contemporaneously, it's just a waste of time. Just try and save as much time as you can. I also, but this depends on the facts. I think I stated the following conducts are assumed to be voluntary and free-willed unless stated otherwise, because usually voluntariness, I know it's a part of actus reus, but usually it's not contentious on the facts. Like usually, the conduct is voluntary. So yeah, that's I guess another tip to just state these at the start. And then if there's any issues with voluntariness or contemporaneity, you can raise them there. Um, so just quickly, speaking to your chief examiner, he gave me a bit of feedback that the faculty had on previous exams, and this I think was what most relevant, and it's kind of good to, I guess, look at where you are right now, where you're sitting, if you're at the least successful end or the best end. So less successful end, it was clear that many students relied on poor quality or outdated notes, and mechanically copied content from them. So that's what I was saying. Make sure, that you're engaging with the facts because they can tell straight away. Also, I had a question on whether the LSS notes were kind of outdated. So the LSS notes, I made them this year based on my notes. But I did do this top I did do this unit last year, first sem. So there might be some things that have changed. I did read your reading guide and most things are still similar. But yeah, just make sure, if there's any inconsistency, once again, just like refer to your ones. Better answers show evidence of individual thinking and analysis. They identify all the relevant legal issues and deal with them in a clear and organized manner. And then the best answers apply the law, discuss contested issues. So very important to like discuss counter arguments for not everything, but if there is a counter argument, raise it. So counter arguments for prosecution and defense. And that's why it's really good to do what I was saying before, the color coding, to, do something in green if it's for the defense, or sorry, for the prosecution, and red if it's for the defense, because then you can make sure that you're sort of hitting all the arguments. Um, Cited sources, and obviously effectively structured. Okay, so those are all my sort of general exam tips. And I've got some more at the end of the slideshow in regards to like actual exam day. But I hope that is all helpful. Now we're gonna go through an exam. There's so much to go through, so hopefully we can get through all of it. I hope that you guys have read it. I did post it on the Facebook page. But all good if you haven't. I will give you like maybe 1 or 2 minutes to read each question. There's 3 questions, I believe. Yeah. There's just a lot of facts, so I don't want to spend too long on it because I do want to give you guys the answers and not necessarily the answers, but like how I would answer it and, the scaffolding and all of that. And this is the best way to sort of revise as well, to go through an exam and the elements. So this is question 1. There's a lot in there. So I'll give you maybe a minute to read that. 2 minutes maybe. And then we'll start answering those. Okay. Um, I hope you guys have had a read of that, and we will kind of go through the main facts together. So don't worry if you haven't been able to kind of identify everything that's relevant. Um, and then we'll answer those questions. So this is from the 2022 exam, by the way, which was also given to you by the faculty. So, if you haven't done it yet, that's okay. Just make sure, maybe jot these things down. Take screenshots if you need, and then try go like have a go actually answering it yourself. Um, so I have highlighted the relevant facts, and I've done that sort of green and um, red method. Um, so just highlighting the relevant people as well, because there's a couple. So Archie gets jealous when he sees Bella talking to friends. Archie started to grab Ella on her arm when he gets angry. Bruises, several bruises. So these are all things pointing towards the fact that Archie, could be guilty of something, right? Also, as I said, most facts are relevant. As you can see, I've pretty much highlighted everything down here. But usually at the start, they kind of set the tone, and so it's not as relevant, I guess. I'm not highlighting everything there. And then Jasper, who trains with Bella, um, comes into the picture. That's really, I wouldn't say that relevant. Yeah, so other facts, Archie consumed a bottle of red wine. We will speak about that. That might point towards intoxication. He grabbed Bella's right hand between his 2 hands, said, "You'll never leave me." But then things that point away towards Archie actually being liable here because Bella started crying, that's relevant. But it tells us that she suffers from a bone disease, a disorder that results in fragile bones that break easily. And her finger, after Archie grabbed her hand, was only, I guess, broken. It healed after 3 weeks. So these are po facts maybe pointing away from his like absolute liability. Obviously, he would still be liable or something, but I guess we call them mitigating factors, where these like, aggravating factors. Um, Bella was sitting very pale, while holding up her hand. Um, Archie picked up his steak knife, jumped from his seat, waved at Jasper, saying, "Stay away from her, or you know what's good for you." Archie then thrusts the knife at Jasper, and Jasper instinctively slaps the knife away, but slices his arm and hits a nerve. Um, and then Jasper's wound results in a permanent lost feeling in his left arm. And then I've just underlined this line because it's only relevant to question 3, so we can worry about that later. For now, we're just going to worry about Archie's liability. Okay, let's break this down. So, quick note for question 1. So Question one was advise Archie of criminal liability arising from the incident in relation to Bella. Now, with intoxication and voluntariness, so I highlighted the fact that he had drunk a whole bottle of red wine. That's relevant, okay? They didn't include that for no reason. But most students make the mistake to then go, oh, he was intoxicated, so it's not voluntary. That's not true. So what you'd say is Archie will argue that he was so intoxicated that his or slash her, sorry, don't know why I put that in there, will was divorced from the movements of his body. So he might argue, oh, I was too intoxicated, I didn't know what I was doing. The prosecution will then point out that while he was intoxicated, he did not exceed the high threshold of the O'Connor test, which is a really high threshold to be divorced from movements of one's body. So that's just a quick note, just like if someone's drinking, it becomes relevant with sexual offences, but with the rest of the crimes, it's not really, yeah, you can raise it, but it's not super important. Okay, so here we can either talk about common law assault or causing injury under the statute. I have so many questions on this, like what crime should I speak about first? You know, which one's most relevant? Well, the answer is you always speak about the ones that are easier to make out first or the ones that are the most serious. I usually speak about the ones that are most serious first. Once again, in a real life court case, they're going to try and prove the hardest crimes to prove first because they're trying to get the person, you know, maximum years of penalty or something like that. So try and prove what's most serious first. With common law assault, most of the time, if there's an application of force, it's either causing injury under the statute, but it can also be common law assault because it's battery. Um, but I would say that common law assault is more relevant when you're actually talking about like apprehension of violence and stuff like that, and we'll talk about that later. Whereas causing injury under the statute is more relevant when there's actual like bodily harm and when there's actual battery. So I guess my tip there is if there's been an application of force, talk about it from the statute. So talk about section 18, 16, 17, all of those ones. Don't go to common law assault. You can speak about both, but it's kind of a waste of words. Here we want to split up the injuries as well. So there's two separate injuries. So the bruising from grabbing Bella's arm. So the grabbing is a direct application of force. And under Collins and Wilcox, even the least touching in anger is sufficient for battery. Causation here is not contentious because, you know, we know that he grabbed her arm and, you know, she was bruised because of it. Grabbing Bella's hand and causing the broken finger. That's another injury. So once again, it is a direct application of force because he grabbed her hand forcefully, and it did result in the injury, the broken finger. But there's a problem with causation here, and the problem is that Bella suffered from this disease, the brittle bone disease, which meant that her bones broke easily. Now, is that enough to say, well, she had a bone disease, so that means that Archie can't be liable for causation? Sorry, can't, you know, causation, the causation is broken because Bella sort of suffered from this from this bone disease and Archie couldn't have known. No, because Blau, I hope I spelled that right. Blair tells us that the defendant, so Archie, must take their victim as they find them. So if you remember from that case, it was about the blood transfusion. The victim refused to have a blood transfusion due to religious reasons. And it was found that you know, just because someone is religious or has certain beliefs, it doesn't mean that the defendant will not be liable for something. So you must find your victim as they are. So basically, if there's any problem usually they do include some sort of bit on causation like this. If that person had that pre-existing problem, so Bella had a pre-existing brittle bone disease, it does not matter if no one knew about it, if you know, that's why she was injured. If the person's act was still a substantial and operating cause, which it was, because her bone ultimately wouldn't have broken if he didn't touch her hand. then it doesn't matter. You must find victim as they are. Um, so make sure you know that because that just comes up so often. Cool. Okay. Now we want to analyze, and I know some people might have not done this for the assessment. Um, if you're talking about causing injury under the statute, so under the law, under the Crimes Act, you need to say if it's an injury or serious injury. You can't assume like even if it's very clearly just an injury, have a line or two stating why it's not a serious injury. So here, I wrote, given Bella's increasing worry about Archie's behavior, so it does talk a little bit about our mental health and how his actions have kind of impacted her mental health. Um, there's a possibility that this could amount to temporary harm to her mental health, and that could be a serious injury under Section 15 because injury, if you guys remember, doesn't just need to be a physical injury, it can also be a psychological or mental injury. However, the more easily proven injuries, so the bruising and the broken finger, are unlikely to be classified as serious injury, um, because we probably need more evidence if they're substantial or protracted. So a broken finger might be substantial, but protracted means that it's for a long time. Usually it's like over 6 months. She healed within 3 weeks, so it probably wouldn't kind of meet that threshold. Um, so yeah, they would definitely just be injuries, especially the bruising as well. That would just merely be an injury. Serious injury, think like a broken leg or something, that um you'll have to live with for like 6 months. So therefore, Bella's psychological distress would be the strongest avenue for arguing serious harm. But um, we would just say that Section 18 is relevant because the bruises and broken fingers are not serious injury, they're just injuries. And then the mens rea. So Andy must have either intended to cause the injury, um, or despite it not being the specific injury, intent still constituted as intention under Westway. Um, or recklessness. So the act would probably cause the injury. So here we can say that Archie's actions, Archie's, Andy's actions, for the two injuries, the grabbing and the squeezing were both intentional. So he meant to apply force. Um, I don't think there's any issue on like intention or recklessness here. If usually someone punches someone or grabs someone or um, squeezes someone, like usually they're trying, if they're doing it, I guess, out of anger or they're sort of intending to apply force on them. Um, they usually are intending to cause some sort of injury. You could also say his jealousy and prior warnings to Bella suggest a motive and awareness of his conduct. So sort of like um, you could say he was really jealous, and so it's likely that he subjectively intended to hurt her. But just note that motive may suggest towards intention, but it is definitely not definitive. So yeah, don't say, oh, that was his motive, so then he's got intention. But I think you could definitely conclude that, he did intend because he was jealous and um, he did intend to do those acts. And so then you would conclude and say, Andy would likely be liable under Section 18 for intentionally causing injury. Um, okay, so that's question 1A. So this is 1B. Sorry that it says 2 there. I might have put the wrong slide on there. But Andy threatening Jasper with the knife. So that's the second question under 1. Now, here there's a lot of possibilities with the offences that you could talk about. So you could talk about common law assault, you could talk about threat to inflict serious injury, or you could talk about causing serious injury. Because we've just gone through the causing serious injury and that avenue, I'm not going to mention it. But you wouldn't talk about all of them in an exam. You just wouldn't have time. So here I would probably say that common law assault was the most relevant one. And we'll see why. So Archie waved a steak knife at Jasper while saying, stay away from her if you know what's good for you. Um, so the positive act, waving the knife, and then also the verbal threat, um, it clearly caused apprehension of immediate violence because he was, pointing the knife in that exact moment. And Jasper slapped the knife away. So clearly you could say that, he did apprehend immediate violence, otherwise he would have just probably stood there. The conduct was without lawful excuse, and the threat and gesture were capable of arousing apprehension of violence, satisfying that requirement from those two cases as well. Even if Jasper laughed at Archie initially, I think on the facts it sort of said, oh, he just laughed and thought nothing of it. It doesn't negate assault from that case if from Brady and Schnatzel, if you guys remember, because the victim's courage is irrelevant to liability. Um, okay, then the mens rea. So I've just put these two in here for you guys because most students just get mixed up like with the wording of these, and it's really important that you've got the right wording because even if you apply it correctly, if you apply the principle from the case law correctly, they can take marks off if you've worded it the wrong way, obviously. Everything in law is very precise and you need to, say the principle word for word because if you change one tiny thing, it could mean something completely different. So for intention for common law assault, the defendant must have intended to contact or to create in the mind of the victim an apprehension of immediate and unlawful physical contact. For recklessness, the defendant must have foreseen the probability of contact or the creation in the mind of the victim of apprehension of immediate and unlawful contact. And that's Campbell, and intention is Westaway. So I think some students write like it must have been probable or it must have been likely for recklessness. Make sure you say it must have foreseen the probability. Because yeah, they can take a whole mark off for that. So here, intention is likely made out. Holding out a knife and threatening just by likely meant that Andy subjectively intended to create in the mind of the victim an apprehension of immediate and unlawful physical conduct. Yeah, if you're holding out a knife at someone, it's very likely that you intend to scare them. Sort of what that's saying. So I guess um, if it's not contentious on the facts, if there's not too much to argue, then just you can just state that. You don't have to go, oh, it could also be recklessness because if it's very easily made out, just say it and move on. They're not going to give you marks for, stating something that's probably too far outside the scope of the question. So if you think something's made out easily, just move on. Um, so for threat, um, So as I said, you could either talk about common law assault for this question, you could talk about threat, or you could also talk about intention or recklessness to cause serious injury under section um, 17, 18. So here we've got threat to kill or threat to inflict serious injury. So from his sentence where he says, um, you won't go near her or if you know what's good for you. I think that was the wording. Now I've just sort of outlined it for you because with the threat, it actually is a rather similar analysis to the common law assault. The elements are very similar. Um, so the act is phrased for threat to kill, voluntarily willed act, and the defendant must threaten to kill the victim. So it says a person who, without lawful excuse, makes to another person a threat to kill that other person or any other person, um, will be guilty of an indictable offence. And the mens rea is intends that the victim would fear that the threat will be carried out. So it's sort of similar test to common law assault, right? To, make them apprehend immediate or unlawful conduct. Threat to inflict serious injury is the same thing, but instead of killing, it's inflicting serious injury. Um, Once again, if you're talking about threat, you have to say why it's not threat to kill, if it's a threat to serious injury. So I've got a little thing here explaining that. So the threat lacks specific explicit language regarding death to be classified as a threat to kill under Section 21. Rather, it can be regarded as a threat to inflict serious injury given the totality of Archie's conduct. So holding out a knife while stating, stay away from her if you know what's good for you, likely, constitutes a threat to inflict serious injury. So while the wording does not point towards him threatening to hurt Jasper, Because I guess, if you just say stay away from her if you know what's good for you, that's not really, if that was the only thing we had to analyze, that would not be a threat to inflict serious injury. But because he's also holding a knife while doing that, um, the totality must be considered and Section 21 would be relevant. Um, so yeah, then you would then talk about the mens rea, and the mens rea is very similar to what we just spoke about in common law assault. So you would say that um, Jasper, likely feared that the threat would be carried out because there was a knife being held in front of him, and he was scared of Archie or whatever. So um, yeah, you would kind of do the similar analysis. But for this question, if you did get this on an exam, I don't think threat is like the strongest argument. I would probably do common law assault and then maybe causing serious injury as well. But you definitely could mention threat. Just with the offences, start from the most serious one. Obviously, threat is going to be less serious than causing serious injury. So, yeah. And then you conclude. So, Andy would likely be liable for common law assault, but as I said, probably causing serious injury under the statute. He may also be liable for threatening to cause serious injury under Section 21. Okay, question 1C. So we're still on question one. That was the big question, so 30 marks. Question 1C, the only facts that we're really given to answer this, I've actually inserted at the top of this slide. So we've got Jasper screamed in pain and kicked Archie so that Archie fell over, hit his head on a nearby table and suffered a gash on his head that required 6 stitches. So is this an injury or a really serious injury? Stitches, I think this is what you guys also had in your assignment. Stitches is not likely to amount to a serious injury, as they're not substantial or protracted. A serious injury is quite, a high threshold. So, um, unless it's usually if it's a serious injury, they'll say on the facts like she couldn't walk for 6 months, or she suffered really severe mental health or something like that. But usually if they just say required 6 stitches, you can kind of assume that it's just an injury. So injury is relevant under Section 15. So then we go to Section 18, which is either intentionally or recklessly causing injury. Now, I've just put on the slide what is required from Section 18. But this question is only 6 marks, just by kicking Archie. So, and the main thing that they want you to talk about in this question isn't actually the causing injury, but it's the defense. And we will talk about defenses, but yeah, so don't spend too long on this. Um, Here it's, we can make this out very easily. So the actus reus, there was a voluntary and willed act that caused the injury because, Jasper kicked Archie. So that's pretty easily made out. Causation's also not contentious. There's nothing to say that. So you would just say, Jasper's act was the substantial and operating cause of Archie's head injury. Um, Mens rea, once again, there's nothing on the facts to suggest that he didn't intend to kick him. So you just say he intended to kick Archie Westaway because he had the subjective intention to, bring about injury or something like that. Nothing on the facts to suggest otherwise. So because it's only 6 marks, they don't want you to spend much time on this, but they do want you to talk about defenses. Um, I got a couple of questions on defenses in the Q&A. Yeah, so a lot of people were saying there's not a lot of exams that go through defenses, like a lot of practice exams. And I found that as well, actually, when I was doing my practice exams, that I can't remember how many practice exams I did. Not too many though, but I think I only had like 1 or 2 questions on defenses. They do come up, but yeah, there's not a lot of practice. So try and like I don't know, make up your own. You can even ask ChatGPT to like make a scenario for you where you can apply defenses. But this is a good example of where you would apply it. So obviously Jasper could argue, well, I kicked Archie in self-defense because he was holding out a knife at me and was threatening to, hurt me. So with defenses, the first thing you need to mention, very important, so many students miss out on marks from this as well, is the burden. So for self-defense, there's the evidential burden. The defense must raise the self-defense. So Jasper would argue, would raise the self-defense, or the solicitors representing Jasper. Then it's the legal burden. So the prosecution, it shifts. So the prosecution must disprove beyond reasonable doubt the self-defense. So just stay at the start of your defense's discussion. By the way, defenses goes at the end of your discussion. So you would conclude, okay, Jasper's liable for causing serious injury under Section 18. However, he might raise self-defense. And then you would need to say, the defense would have the evidential burden to raise the self-defense, and the prosecution would have the legal burden to disprove this defense. Just make sure you state that. So under Section 322K1A, the conduct must be necessary in self-defense. Now, I think this is pretty easily made out. Archie threw a knife at Jasper, um, and causing, his arm to slice open. So arguably it was necessary to fight back. Um, Without Jasper's response kicking, Archie may have caused further harm. You could always mention that. If he didn't defend himself, then further harm might have ensued or something like that. That would be a good argument. Um, and also Jasper's action can also be necessary to protect Bella from Andy. So with self-defense, and a lot of students miss out on this as well, it's not just defending yourself, even though in the name, that's kind of what I suggest. It can also be defending someone else or defending property. So it could also, yeah, be, I guess, defending your house if there's intruders or something. All needs to be reasonable. So, if someone comes into your house, you're probably not going to kill them. But yeah, it doesn't just need to be defending yourself. So you could make the argument that he was also trying to defend Bella. Um, Under Section 322K1B, Jasper must have believed the response was reasonable in the circumstances. So this is a subjective test. So this here is an objective test. It must be necessary, I guess, to a reasonable person. And here it's a subjective test. So to Jasper. Um, Kicking someone who had thrown a knife and caused serious injury is likely reasonable. And Jasper, we're told that he was afraid. We're told that he was agitated. So once again, could be made out. Jasper, so then if the defense is made out, then it means that Jasper's not liable. And yeah, the defense has, I guess, won that argument. Okay, that was a lot. Hope that all made sense. Let's go on to question two now. This is only 10 marks, but there's actually a bit to talk about. So I'll give you guys maybe a minute to read it, and then we'll go through the answers for that one. Okay, let's go through what's relevant here. Um, so only for 10 marks, there's actually a lot to talk about. Usually should be more worth more marks, to be honest, but um so the mitigating factors are the fact that I took some aspirin. Sorry, I've done it the wrong way around. Anyways, so the fact that the aggravating factors are the fact that Bella was frightened and she flinched. So just imagine that's in green. Archie stroked her breast. The mitigating factors are that she was drinking, um, but she was shaking, so she was scared. Um, He said, "You stink of alcohol, you know what you want, I know what's best for you." She said, "I just want to be happy." Um, and then he sexually penetrated her. She was in shock and did not say anything. Usually, with sexual penetration, that's one of the elements, obviously, of actus reus. You need to actually have sexually penetrated. Usually, that's not like contentious. So, yeah, we'll speak about that, but you can just say he sexually penetrated her. That's not usually what's contentious. It's more the mens rea. So, so here what's relevant is rape and then also sexual assault because he was touching her breast before he sexually penetrated her. But because rape is the most serious offense, we're going to go through rape first. So under section 35A1, Archie sexually penetrated Bella. You can just say that. You don't need to say anything else. It's hard for that to be contentious, right? Like usually, yeah, they just tell you. Um, There also must be a lack of consent. So that's sort of the second element, consent being free and voluntary agreement under section 36(1). So in section 36AA1, there's so many sections here, there is a whole list. There's like, I think it goes all the way to like M or something, I can't even remember, of things where consent, like factors pointing towards consent being vitiated or negated. So make sure you've got those in your notes because I can 95% assure you that it will be on one of those, like what the exam will be. It will sort of relate to one of those. So just make sure you know all of them. So consent is negated where Bella did not say or do anything to indicate consent. 36AA1A. Bella took aspirin and drank heavily, so um, the fact that she was slurring her speech, meant that she was probably drunk and probably incapable of consenting. That's under 1G, subsection 1G. Um, Also raise the jury directions here. So very good jury direction to raise is that if any of section 36AA1 circumstance is met, then consent is legally negated. And usually, as I said, one of the 36AA1 will be relevant because it's a really long list. And they've pretty much included anything that could happen. So yeah, you can definitely always mention that new jury direction, which is good. So AR is satisfied. Now, mens rea. So under section 38(1)A, he intentionally sexually penetrated her. Once again, this is not really going to be contentious on the facts because if someone, sexually penetrates someone, usually it is with intention. It can't really be reckless. But then the hard thing to prove here is Archie not reasonably believing that Bella consented. So first of all, under 36A2, he did not ask Bella if she was consenting before the act. Um, his comment being, "I know what's best for you," is not sufficient to form reasonable belief. So if you remember this case, the Bashki case, it said that the defendant must take reasonable steps to obtain consent. So usually that means they have to ask the person if they are consenting. If they haven't asked, well, they haven't taken reasonable steps. Defense might argue, always, raising arguments from both sides. Defense might argue, prosecution might argue, make sure you're doing that for that HD response, as, the examiner report said. Um, Bella said that she just wanted to be happy. However, this is not explicit consent. So sometimes, people say things before sexual activity, um, unless she specifically says, "I want to engage in this," um, it will not be consent. So don't get caught up in that and don't like, I guess, get tricked by that as well, because it's not explicit consent. It must be explicit. The defense might also argue that since they were in a relationship, and sex was usual, it was consensual. But the jury must be directed, once again, another Jury Directions Act, that past consensual sex does not equate ongoing consent. This is section 47FA of the Jury Directions Act. Really important one. If there's ever a scenario with like boyfriend, girlfriend, ex-boyfriend, ex-girlfriend, you can raise that. Bella pulling away early and being clearly intoxicated weakens any claim of reasonable belief. Um, Jury must also be directed. There's no typical response to rape. So someone might just guess go along with it. And a person might be raped without resistance. So due to shock, which is what happened in this case. That's section 47EB. So MR elements of rape are satisfied. So yeah, this is like a difficult one. I think rape just takes a long time to go through, and there's just jury directions and everything. This is definitely like the questions that took me the longest, and there's so many sections that you need to talk about. Whereas like with murder or manslaughter, you kind of just like include the cases. So yeah, I guess try and get fast, and that exam script will really help in getting faster answering questions like this. Okay, question two. So still the same question. We've done rape because that's the most serious offense. Now we're going to go on to sexual assault. Um, Most of the time where there's rape, there's sexual assault. I mean, if there was no mention of Archie touching Bella's breasts, then it probably wouldn't be it wouldn't you wouldn't mention sexual assault just because it would only be rape, but because there's that mention, then we know it's relevant. So that section 40 is sexual assault. So Archie touched Bella. That's the first element. There must be touching. Um so the fact that he was stroking her breast constitutes touching. Um, Make sure you know as well that if it's touching over clothing, it still constitutes touching. So, like if she still had a top on or something, it still constitutes touching under the legislation. So that's 35B1. And then the touching was sexual. So must be touching and must be sexual. So that's under section 35B2A. Um, it sort of states what body parts constitute as sexual. So obviously for a woman, it says that breasts, and yeah, different body parts as well. But yeah, you can just conclude on that. That's not really contentious. B as well, C, sorry, Bella did not consent, so that's the last element. She was frightened and flinched. So there was no issue there on like whether she said anything. He just sort of started touching her breast and she was frightened and flinched. So you can definitely say there that she didn't consent. Um, Flinching, jury direction, you can raise flinching or freezing is not consent, and non-resistance does not equate to agreement. So the actus reus for assault is satisfied for sexual assault. And for the mens rea, just to not go through the whole thing again, it's a very similar analysis because it's actually pretty much the same thing. They need to have reasonably believed that the person was not consenting. So for mens rea, um, you would talk about the same things that you did for rape. So you would talk about pretty much same Jury Directions Act, and you would talk about, yeah, the same elements. Did he reasonably believe that she was consenting? Um, and once again, that's probably not made out here. So you would also conclude that he would be liable for sexual assault as well. So yeah, Archie would be liable for rape, although he may be considered liable for sexual assault. This is not as strong an argument. I mean, you can just say he's liable for both. I guess you can say, well, being liable for rape is stronger because I guess that's a more serious offense. But uh, yeah, I would probably redoing this. I would probably conclude that he's liable for both. But um, yeah. Okay, question three. Nice. I've already highlighted the facts for you guys. So I will give you maybe 2 minutes to read this one, and then we will go through um those. Okay, let's go through this one. So for the first question, stalking, so it relates to stalking, but stalking wasn't accessible in my year, but I've still gone through it just based on, reading the legislation. But yeah, I don't really have any sort of notes on that just because it wasn't on our exam. But I will still go through it. So what's relevant here is, well, this stuff kind of relates to the stalking aspect, but the fact that Archie came up behind um, Jasper and punched him in the back of his head. Jasper fell and struck his head on the pavement, rendering him unconscious. Then Archie dragged Jasper into the side street near him and left him behind in a rubbish bin so no one would notice him. Um, he wanted him to wake up the next morning with a terrible headache. Um, so that's sort of pointing away towards murder. That's why I put it in red because we can see that, he really did not want to kill him or anything. He just wanted to sort of leave him with a headache. Unknown to Archie, Jasper suffered hematoma, which caused swelling in his brain, and he died a few hours later. Medical evidence showed that if he had received medical attention immediately, it is likely that he would have survived. Okay. Um, let's go through the first question. So, stalking, section 21A. So, actus reus, Archie must have engaged in a course of conduct, including at least one of the following. So, following the victim, he did follow Jasper all day, trailing him and taking photos of him. BA publishing on the internet material relating to the victim. So he posted photos of Jasper on Instagram, tagging him. Um, he also kept the victim under surveillance, so he sort of continuously was observing him, and he was loitering near the victim's place of business. He waited near his workplace. So these are all elements under the statute. So you would say um, all of these are sort of factors pointing towards the actus reus being made out. Then we go on to mens rea. So under section 21A(3), Archie must have the intention to cause physical or mental harm to Jasper or arouse apprehension or fear. This intention is also established if Archie knows that his conduct is likely to cause harm or fear, or Archie ought to have understood that his conduct is likely to cause harm or fear. So here, if we apply that to the facts, well, Archie intentionally followed and surveilled Jasper and posted photos, indicating an intent to cause fear. He should have known that persistent following and public posting would likely cause Jasper fear or distress, and Jasper's agitated behavior when leaving work supports that apprehension or fear was caused. So when you're trying to make out like apprehension or fear, always kind of look at how's that person feeling. If there's any facts to suggest that they were actually scared, then you can say that it's made out. So yeah, that's kind of, I guess, a good way to think about it. Okay, so then you conclude that he is likely criminally liable for stalking under Section 21A. All right. Now, important note on this. So murder and manslaughter, if you guys remember from the tutorial that we did do on that, and if you went there, that's okay. But murder and manslaughter basically were one offense many years ago. Many, many years ago, it was an offense under homicide. And so there was no distinction between the two. Now there is a distinction because I guess, for policy justification reasons, they sort of wanted to make people liable if they actually had intent or were reckless as to whether to kill someone, whereas if someone sort of, I guess, make someone less liable if they didn't have meet that high threshold under manslaughter. And the reason I'm saying that is because you still need to consider both. On the facts here, it is probably very easy to say that, yeah, it's just manslaughter, because it says that he just wanted to give him a bad headache. So, we can't really say that punching someone in the back of the head, um, I guess, like constitutes murder. But you still need to go through murder and then say why it's not made out and then do manslaughter. The reason for that is because the actus reus is the same, right? It's, he's done the same thing, but then you need to talk about, and we'll go through it together, but you need to talk about the mens rea and say why the mens rea is not made out for murder. Because if there's no mens rea for murder, then yes, of course, manslaughter comes in. But you first need to prove that murder would not be applicable. And once again, if this was a real life court case, the prosecution would always try and argue murder because the person would be imprisoned for a longer amount of time. So make sure that when you're approaching a homicide question, you go through murder first and then you go through manslaughter. And that's why these questions take so long, because you have to go through three offenses basically. Okay. So let's go through that. And sorry, just one last thing. I did have a lot of questions on like, um, yeah, should I raise an offense if I don't think it's relevant? No, usually. So if like sexual assault isn't relevant, don't go, oh, it might be relevant because of this, but ultimately it's not. Um, like don't engage in an analysis if you don't think it's going to get you any marks. If the question's 6 marks and it's a rape question, that's probably they just want to talk about rape. But the only exception to that is murder. Because even if it's not relevant, you still need to raise it to then get to manslaughter, basically. Unless there's a question that says just discuss manslaughter. They might give you that, they might be nice. But if there isn't, discuss both. Okay. So, actus reus for murder. So, Archie punched Jasper in the back of the head. This was voluntary and free-willed. And Jasper died as a result. So, those are the two sort of things that need to be made out. You do need to say that the person's died, and usually that's made out easily. They'll tell you Jasper's dead, but you need to say just, one line saying Jasper died, and his death meets the definition of death under Section 41 of the Human Tissues Act 1982. Irreversible because it's an irreversible cessation of circulation and brain function. You don't need to say that bit, but you do need to say that it's death under Section 41. And make sure, once again, if you've put at the start of your exam, all these sections relate to the Crimes Act, that you do state Human Tissues Act after. Okay, causation. Um, so Archie's punch was a substantial and operating cause of Jasper's death, for sure. Um, there is no break in causation, no novus actus intervenus. Although Jasper did not seek medical assistance, Blair confirms that a victim is not required to mitigate their injuries. Also, he was, unconscious behind a bin, hiding somewhere, so couldn't have really sought medical assistance. Um, and yeah, so the actus reus elements for murder are established. And usually they will be if someone's died, unless there's a really big problem with causation. But then the important analysis then is mens rea. So why is mens rea not made out? Because if it was made out, then we would be finding him liable for murder. So the mens rea for murder requires intent or recklessness to cause death or really serious injury. Um, we are told usually they don't tell us what the defendant wants or thought, but we are told that he intended to give Jasper a really bad headache. So this is unlikely to amount to intent or to kill or cause really serious injury. Recklessness may be arguable, as he hit Jasper in the head, um, but he likely did not foresee serious injury as a probable result. Now, that's not entirely true. You could definitely argue recklessness for this. The reason I haven't is because this question is, let me just go back. Oh, I will not be able to find it. I think it's like 20 marks or something. Um, and so you know that they don't just want, because if you make out murder, well, then what's the point of discussing manslaughter? Obviously, what you could do is say, well, actually, recklessness is made out here, but I'm still going to discuss manslaughter just in case. But usually, on the facts, if there's something like He didn't intend to hurt him. He didn't want to do anything bad to the person. Usually they do want you to discuss manslaughter and they want you to sort of conclude that murder's not made out. Just remember, murder's a really high threshold. It's the most serious crime. So like, I guess don't always conclude that murder is made out. Okay, so you would say murder is unlikely to be satisfied, or maybe it is likely to be satisfied, however you want to argue it. But then you would say Archie is more likely to be found guilty of manslaughter. So, so many questions on this as well. So there's two types of manslaughter, UDA manslaughter and criminal negligence or negligence manslaughter. You usually, like people were just asking, oh, do I discuss both? Do I only discuss one? It depends on the facts. If they're both relevant, discuss both. If only one's relevant, only discuss one. Um, so on these facts, they're both relevant. So we are going to talk about both. Um, but sometimes they won't be. So yeah, it depends. So unlawful act requirements. So that's the first bit. So punching Jasper is unlawful, as it constitutes common law assault. Okay, so remember, for UDA manslaughter, you need to have a foundational offence, and usually that will be common law assault most of the time. So it could be sexual assault as well. They could do that because, sexual assault is unlawful, or it could be rape or something like that. But yeah, there must be an unlawful foundational offence. So once you've found that, then you have to prove that foundational offence. So you have to go through the actus reus and the mens rea. So the actus reus of assault, we can, say that Archie made non-consensual physical contact because he hit Jasper in the back of the head. And then the mens rea, Archie also intended to injure Jasper, pretty easily made out if someone's punching someone on the back of the head. So both of those elements are made out. Then we also need to prove dangerousness. So the unlawful act must objectively be dangerous. That's Wilson. And there's this little section of the Crimes Act that so many students just like don't have in their notes or just miss out on, that actually tells you that a single punch to the head causing head injury is deemed dangerous. So, a reasonable person, I guess, would recognize um, this act as exposing another to an appreciable risk of serious injury. The reason this was inserted is because, sometimes I think there was a case like many years ago, obviously the law evolves with cases and with judicial decisions, that's the common law. Many years ago, it was sort of decided on a case that um, like it was argued, well, is a single punch dangerous or not? I guess you can argue that maybe it's not dangerous. So then they included that in to just say if it's to the head and if it's a punch to the head, it's deemed dangerous. Also, another tip, I guess, if on the facts you're talking, you can see, oh, he punched him in the back of the head or he punched him in the head and then the person died. They usually want you to discuss manslaughter just because of this section here. Um, Cool. So UDA manslaughter is satisfied. So we've made that out. But we also need to consider negligent manslaughter. So this is a really big question. The homicide questions are so, so big. Um, so first we need to prove the duty of care. So there, if you guys remember, there are multiple cases where, it says like it kind of has they establish a duty of care, the different cases. And the tac case basically said that if you assume responsibility of someone who is unable to care for themselves, then you do have a duty of care to help that person. So Archie hid unconscious Jasper behind a rubbish bin and sort of isolated him from assistance. This creates a duty of care through an assumption of responsibility for someone unable to care for themselves. So it's very similar to that tac case. Another thing, another tip, I guess, is know your cases well. You don't need to know the facts super well of every case. Like I definitely only sort of, knew what happened, but most of the time the questions, the novel factual scenarios they give you are similar to the cases. Like there'll be some sort of similarities because they want you to analogize the cases and they want you to make comparisons between the cases. So here it's very easy to go, oh, okay, this is what happened in Tac because he isolated someone from assistance as well. Like hid a girl in his hotel room or something, I can't remember, or left her there. And so it was found that he actually did have a duty of care to that person. So duty of care is made out. Um, then we need to talk about the breach and the causation. So Archie's omission, which was failing to seek help. So he didn't actually do anything. It was more of an omission to not seek help, breach that duty. And this omission contributed to Jasper's death by preventing timely medical assistance. Um, so causation is likely satisfied. Um, Criminal negligence. So we need to talk about, well, did this conduct involve a gross breach of duty? So it would be arguable, and you can argue both sides. Always, you can argue both sides. This is just how to approach it one way. Um, you could say that it definitely constituted a serious departure from what a reasonable person would have done and involved a high risk of death or really serious injury. Leaving someone there who's unconscious, kind of isolating him from assistance. Um, this would meet the threshold for criminal negligence, and negligent manslaughter is therefore satisfied. And then you conclude on that. So Archie is liable for both UDA manslaughter and negligent manslaughter. Archie could be liable for murder to recklessly cause serious injury, but this is not as strong an argument. So once again, you see how all the conclusions that I've made are sort of tentative. Um, I've said he is liable, but I probably should have said likely in there, but doesn't matter too much. But just make sure not all of your conclusions are he's definitely like don't say stuff like definitely or just make a tentative conclusion of what you think is right. Okay. Um gosh, that was a lot to get through. So hope that exam um made sense. I sort of spoke, I guess, to your chief examiner about that exam. So this was 2022 one, and there was just some general feedback. Mostly it was done well, actually, so that's good. The biggest like piece of feedback was obviously that people didn't finish. As I said, like 90% of people don't finish the exam, and that's completely normal. So if you don't finish the exam, that's okay. But these are just some of the like things that I guess where people went wrong mostly. So first of all, mixing up the actus reus and mens rea. Um, People, I don't know why, but some people like to discuss them together. Um, they sort of kind of like go back and forth between the two. I would really not recommend doing that. If you have clear subtitles of actus reus and then a clear subtitle of mens rea, that's going to be so much better than just hopping between the two. And the examiners don't really like that. Um, Failing to analyze causation or novus actus intervenus. So many people lose marks on causation. I think that's probably the part people lose most marks on, and it's usually the part that's most contentious. So make sure you've got a really good understanding of causation. Very important. Okay. Not identifying the foundational offense in UDA manslaughter. So we said that it was common law assault. Most of the time it is. As I said, it could be sexual offenses. I actually haven't seen a question on that, but um, yeah, it could be. It could be like rape and then someone dies from that. So, I guess just make sure you know that you have to find the foundational offense first. There was a lot of inadequate mens rea analysis for murder. So once again, if you say that it's manslaughter, you need to say why there's no mens rea for murder. People not prioritizing or evaluating the most likely charge. So the most likely offense. People just sort of discussing everything. In law exams, it's really easy to get caught up in wanting to discuss all the issues because there's so many issues and you guys might find a lot of issues and go, that's relevant, that's relevant. But I guess the problem with that is um, they're not going to award you for finding every single possible issue, but they're not going into depth on those issues. So it's better to choose the strongest arguments and actually show them that you can find the strongest arguments because it's not really a skill to identify everything and not know what's relevant. So the skill is to find the strongest arguments and go into depth on those. And they will really award people that do that. So obviously raise things that you think are relevant, but not everything. because then it means you don't have an in-depth analysis of the important things. Um, Ignoring or failing to cite relevant statutory provisions. So this is just like people, rushing and obviously typing really fast. I would like highly recommend just highlighting all of the statutory provisions in red, just so they like pop out at you when you're in an exam because it's really, really easy to miss it. Or, when you're writing section 45 AABB, it's very easy to just make a mistake. Um, Omitting mens rea analysis for assault in UDA manslaughter as well. So like, yeah, when people find the foundational offence, they just go, oh, it's common law assault, and they don't actually evaluate the actus reus and mens rea. Make sure that you find the foundational offence, but then you also like prove it. Um, and then a lot of people, I think, overcomplicate with irrelevant facts or sort of legal detail. Um, you can say in an exam, you can say we'd need more facts on this to determine this, but most of the time, like you don't need to speculate. You don't need to go, if we had more facts, this could be relevant. You just don't have time for that. So yeah, that's sort of some general feedback for that specific exam. Okay, and then I just wanted, I guess, in the last couple of minutes to talk about exam day because this is your first law exam. Well, I know you've done the FOL exam, but that's in person, not in person, at home. So I guess not as stressful. You had kind of a longer time period as well to do it. So before the exam, I'm not sure actually what time it is. All of my exams this semester are like at night at 5:30 to 8, which is just horrible because I'm going to be so tired. But sleep well the night before, um, eat smart, so something, it's a long exam. It's like a 2.5 hour exam, probably longer than most, I mean, similar time to the VC exams. So maybe have something with protein or like slow burning carbs, so something that will keep you going, especially if it's during like dinner time or lunchtime. Um, yeah, you'll just be used to eating at that time, I guess. Arrive early. So many people, they do let you in if you're like, I think if you're 15 minutes late. Oh no, actually, I think you can be an hour late and they let you in. And then they just restart your time. I'm pretty sure. It might have changed, but yeah, just try and be there early. And like either talk to your friends or if your friends are gonna be like, oh, I heard this is gonna be on the exam, or oh, I'm gonna stress you out, then just like be by yourself, reread over your notes, listen to music. Bring the essentials. Don't stress yourself out on exam day. So student ID is very important. Otherwise you will not be able to sit it. Laptop and second device. Printed notes. I did mention this before, but I would really recommend, if you've got a second device, great, bring that in because it's obviously quicker to go Control F than be flipping through pages, which is what I was doing during my exam because I didn't have a second device. But um, printed notes, I would still just print your notes because if something goes wrong and if your second device like shuts down or dies or something, I don't know if they can let you reset the exam. I'm not sure about that. I know if your actual laptop, like if the actual device you're doing your exam on fails, then yeah, of course you can. But with the second device, I'm not sure. So I don't know, just I guess to feel better and not stress yourself out, water bottle and watch as well if you want. But you've got your laptop to look at the time. Um, and then after the exam, this is really important because so many people like go up to everyone and go, "What did you write? What did you write?" As you guys know now with law, like there's no right answer. There's never a right answer. So there's no point going up to your friend and going, what did you write? I'm sure you can compare answers and talk about it if you want to. But don't stress yourself out if someone wrote something completely wrong. That happened in my torts exam. Like I wrote something completely wrong to everyone else. And I still, ended up getting a higher mark than them. So, and I thought I was like so wrong. So yeah, don't worry about that. So don't dwell on what you forgot or said wrong. And yeah, avoid those lengthy post-exam chats in the LTB, which you will see people doing. And then be kind to yourself as well. First law exam, law is a really difficult degree. You know, s- all of you guys are like some of the best students in the state, and that's why you got in. So the fact that you were able to make it through your first exam is really important. And Yeah, I guess congratulate yourself on that. And it's one exam out of your whole law degree. Also, your WAM first year only counts 50% towards your grade. I don't know if you guys knew that. So from second year, your WAM counts 100% towards your grade, which is stressing me out because I did well in first year and now I'm like struggling more. But yeah, so I guess it's not end of the world in the grand scheme of things. And then celebrate after the exam. Yeah. Okay. So I will stop sharing actually. But I hope that I have gone. Okay, no, I do have a fair bit of questions, so I will go through those. But feel free to hop off if you guys yeah, don't want to hop off. And if not, yeah. Um, all right, cool. So I will go through these. So mark allocations already set out for this year's exam. Yep, they're the ones that I have got on there. Sorry guys, just give me 1 second. Um, all right. So um then the second one, we've got a jury directions only for sexual offences. Yes. Yeah, you don't need to worry about jury directions for anything else. Um, should you do the exams timed? I would probably recommend doing like the first couple of exams not timed, like maybe one or two, just to like get the hang of things and all of that. But then yeah, do the rest of them timed. Yeah. Or no, like maybe do two untimed, two timed, or however many you want to do. That's important because otherwise you just will not understand like how time pressured it is. And also it's good to like test out that script that you've made. Um, this mean we just turn our notes into practice answers basically. Do we just write this in every answer? Look, it's up to you. Like it really is. Some of my friends didn't sort of have a script and they still did really well. So I just, for me, as I said, I had 10 minutes left over in my exam and I know most people didn't finish. So I think it just saved me a lot of time to sort of have stuff like not pre-written, but I guess like formulated in a sentence way. I still knew I had to apply everything to the facts, but yeah. Um, but basically, yeah, if you want to do that, I think that's a good method. If intoxication is involved, then do we discuss voluntariness? Yeah, so you can write have that little sentence that I put in. Um like if you guys remember I had that little sentence where I said from Connor, if the person's so detached from bodily movements, then they might not be liable, but it doesn't meet the high threshold. Um but yeah, usually it's not super relevant. Could you simply state there is no evidence that the injuries were substantial and prolonged, therefore it cannot be described as serious injury? Yeah, you probably might want to engage a little bit more in the facts. So maybe you could say like something a little bit more like since I don't know, this was only stitches, or since this is only a bruise, it can't there's not enough evidence to suggest that. Yeah, you can definitely say that. If there's nothing on the facts, you can just say nothing on the facts to suggest that this is substantial or prolonged. For sure. Yeah, you don't need to delve into a lengthy discussion about that. How do you go about proving subjective foresight in the mind of the accused? Is it enough to rely on the circumstances and actions of the accused before and after the conduct? Yeah. Yeah, for sure. Just rely on everything they've given you and with foresight, I'm guessing you mean recklessness. Um yeah, usually if it's not intention and you've found that it's not intention, if the facts and circumstances point towards foresight, that's all you would use. Don't speculate on anything. So for question 1B, would you only go through common law assault as it is most likely made out, just as we went through this exam in class and we went through all three? Yeah, as I said, like you can discuss all three. That's why I put all three there because they are all relevant. But I just don't think in an exam you would have time to discuss all three. You could like do dot points for maybe the two that are less relevant. It really depends on your time efficiency. I only went through two as well because I had already gone through the proving serious injury in the one beforehand. So I guess that's why I only went through those. But yeah. Um, What does contentious causation mean? So when I wrote causation's not contentious, it just means like it's not that like it's easily made out. There's nothing really to discuss, or there's no problem there. Also, I just realized someone said they did this exam in class. I'm sorry about that, guys, if you went through it in class, because I asked Anthony, the chief examiner, to send me an exam that you guys weren't doing in class, and he said they were doing another one in class. Like his like he'd instructed all the lecturers to do a different one. So he sent me this one to do. So I'm not sure if your lecturer maybe I don't know didn't didn't do that, but yeah, apologies about that. I kind of just followed his instructions on that. Is it necessary to mention legal and factual causation for each offence? Yes. So the but-for test and then the substantial and operating cause. Yeah, mention both. Can you explain the two type of legal tests? I'm not sure what you mean by that. If you mean causation, then yeah, the legal causation is the substantial and operating cause, and then the factual one is just the but-for test. If the mens rea analysis is similar to the previous part of the question, can we just say see above? Yeah, you can. Yeah. Obviously change it, like you might need to change specific wording of it if it's for sexual assault, because it's not reasonably believing that she didn't consent. But yeah, um, like if the fact scenarios are different, but if it's exact same analysis, and when I say exact same, make sure it's the exact same, then yeah, you can just say see above. Is stalking accessible for us? I think it is because when I asked Anthony what was accessible for you guys, um, it was everything. So yeah, I think um, I think it would be um, accessible for you guys. Using question three as an example, would you recommend starting with the most serious offense, murder, or the offense that is most likely to be made out? Um, I started with stalking first. Well, I started with stalking first because question 3A was about stalking, and then question 3B was about homicide, so murder, manslaughter. But yeah, so that's why I started with stalking first because it was a part of a different question. But I guess, yeah, just mention what's most relevant as serious first. Do you have to separate negligent manslaughter by act and omission? It's pretty much the same test, so no, no. They can't really be both. I mean, actually, no, it could be. There could be. If there is, yeah, if there is, then you can definitely. I'm just trying to think. I've never actually done an exam where like it's both negligent act and negligent omission, but yeah, you'd probably split it up if they're both relevant. Then yeah. Um, One question: would I be able to bring in a dictionary? Yeah, you can bring in literally anything you want. So yeah. Um, So, someone said, if I'm a bit confused on how someone can be charged with recklessly, intentionally causing grievous bodily harm as a mens rea under murder, um, if murder causes the death of another human and would not, okay, would it be, yeah. So, for mens rea for murder, when we say, so the test is either they intentionally or recklessly, in like cause the death, or they intentionally or recklessly wanted to cause grievous bodily harm. Someone still dies in murder, like someone has to die for it to be murder. But we're just saying that it can still be made out if someone intentionally or recklessly wanted to cause grievous bodily harm. So the death still occurs. It's just did they intend for the death or did they intend for grievous bodily harm? Because that can still be murder. Okay, three questions we've got here. So for question one, was causation made out? Did Andy still cause Bella's injury? Yes. Yes, he did because Blau said that you must take your victims as they are. So even if, she had a rare bone disease, that doesn't matter because that was pre-existing. And even if he didn't know about it, his conduct was still substantial and operating cause. If the homicide is not manslaughter and was murder, do you still have to consider whether or not it was manslaughter? Probably not. No. Depends on the facts. You need to see how many marks the question is. Like, I really can't say definitively, but no, usually you wouldn't have to do that. For UDA manslaughter, do you have to go in much depth of AR and MR for the foundational offense? as if you are considering the act as an offense by itself. Um, no. Usually it's common law assault, and they're not going to give you facts of like, a problem with causation on that. So no, usually it's pretty, you don't go into too much depth. Like usually, you just write one or two sentences for actus reus and mens rea. Because that's not like what they're testing you on there. They're testing you on the manslaughter. So it's just a little element of the manslaughter. What did the green and red highlight mean at the start? So I just said at the start that how I go through facts is I highlight in green the aggravating facts and in red the mitigating ones. So basically, what the defense will argue will be in red and what the prosecution will argue will be in green. And the reason I do that is because to get a HD, you need to discuss both sides, both arguments, and there's going to be facts pointing towards a person being guilty and facts pointing away from a person being guilty. So you need to discuss both. How do we differentiate between common law assault and threat to kill? Um, this is a good question because usually they're both relevant. I think it just really depends on the facts and you can discuss both a lot of the time. So you kind of just need to make that decision and, discuss everything if you can. What is the difference between reckless murder and manslaughter and also between UDA manslaughter and constructive murder? Um, Reckless murder and manslaughter. So manslaughter is negligence. Um, I know they can kind of overlap. As I said, if you need to discuss manslaughter, just look at the facts and just figure out, well, um, do they want me to talk about manslaughter? Is there enough evidence pointing towards that? Um, Usually, I would say if there's enough marks for you to talk about manslaughter and it's reckless, maybe you make out reckless murder, probably talk about manslaughter as well. If you're not sure, if it's not conclusive on the facts, if it's murder or not, then do mention manslaughter if you're not 100% sure that murder's made out. But you're just gonna have to look at the marks and go, oh, okay, this is, asking me for more than just murder. What's a pass or fail? I'm actually not sure. But I think it's 50%. I could be so wrong, guys, so please don't listen to me on that. I think it's like 40 or 50. But you don't need to pass the exam to pass the whole unit as well. So I don't know, you might like your average might be 60 right now, and then you get 40 on the exam, you can still pass the unit. But yeah, I'm actually not sure what the pass or fail is. I think it's around 40 or 50. How should we allocate marks? Is there a specific amount of offences we should run through to meet all the marks? So what I kind of put at the start of the slides, with the marks is, kind of divide the amount of time you have by the marks. So ratio over time. With offences, like, so if it's I think for question one, I'd put 60 minutes. So you have 60 minutes to talk about question one. So do everything you can in those 60 minutes. If you can talk about five offenses for question one, then do that. If you can only talk about like, I don't know, four, then do that. Like spend those 60 minutes getting everything in you can for question one, and doing a good analysis on each. Is it better to say prosecution will point out or the prosecution may point out? Um, Doesn't really matter. I would always say on the tentative side, just because like you guys, you're not a lawyer, you're not a judge, like you don't know. But it doesn't really matter to be honest. We need to write out about stalking, even though we haven't learned about it. Okay, so if you guys haven't done stalking, because we hadn't as well, but Anthony did say it's all relevant, all the reading guides. So but no, if it's not on the reading guide, don't worry about it. So I kind of went through that even if we didn't need to. How many cases would you recommend we refer to throughout the exam? And also, do we expect the examiners to know the case? And can we say in brackets or do we need to discuss the facts? No, no. Expect that the examiner knows everything. They do know everything. You don't need to discuss the facts of a case. You don't need to go, oh, and blah, this is what happened. Like you're just wasting time. Do not do that. Yeah, they know what's going on. You can just say analogous to blah, or I'm drawing an inference from blah. Just state the principle, not the case. And yeah, you can just put it in brackets. You don't need to do AGL. My tutor said that you may not need to mention legal and factual causation for common law assault. Is this correct? Um, for common law assault, well, if your tutor said that, then I would listen to your tutor. Look, probably like it doesn't hurt to add a sentence saying but for, but you definitely need to talk about legal causation, but um it might not be relevant. Actually, as well, for common law assault, if it's like an apprehension of violence and if it's like a threat, then yeah, you probably don't need to talk about causation because usually it's made out. Like that's probably what he was referring to actually. So if there's a threat to, I don't know, inflict injury or something and you're talking about common law assault, then yeah, you don't need to discuss causation, I believe. Regarding factual causation, would we have to briefly state, but for Archie grabbing? Yeah. Yeah, like factual causation is very easy. You just wrote, but for Archie grabbing, this wouldn't have happened. So it really doesn't hurt to state it. Would it be okay to address offences chronologically rather than most serious to least serious? Um, yes, yeah, you can do that if that makes sense to you. I just wouldn't just because like each question requires a big discussion on one defense. And usually, that's like the most serious one. So if you then run out of time and you've started with sexual assault, but then the main offense there is rape, well, you've run out of time, and you haven't maximized your marks. So that's why I say start with the most serious one because that's where most of the marks will be. But it's up to you if it makes sense in your brain to do that and you think you'll have time, then yeah. So if it is found that they recklessly, intentionally cause grievous bodily harm, can they be charged with murder or are they charged with manslaughter? Um, So they must have intentionally or recklessly wanted to cause grievous bodily harm, which then resulted in death. Then, yeah, they would be charged for murder. When we write at the start of the exam that all sections refer to the Crimes Act, where do we actually write that? Because isn't the exam divided by the questions? Yeah, it is. I just wrote it, my first question. But look, don't do that if you like don't feel comfortable with it. That's what I did, and as I said, I got the score that I got. But yeah, if you don't want to do that, like you can just write CA. I mean, I'm sure it'll take you 0.01 more second each time. But yeah, I just wrote it like at the start of one question because they kind of just read that and then they'll go, okay, this applies to everything else. Hi, sorry, I'm a bit confused on whether this is handwritten exam or on the computer written out. So yeah, it's on the computer. Everything's on the laptop. So get fast at typing, I guess. Because yeah, it's all on the laptop, which I don't really like. But I mean, I know a lot of people prefer the laptop over handwritten. Okay, cool. I think those are all the questions. Sorry, I kind of sped through those, but yeah, feel free to go back on this. This will be up on YouTube like in maybe by tonight. So yeah, um, I will keep answering, but feel free to hop out of the meeting. Um, Maybe 3 more minutes of answering if anyone has any other questions. So, are you able to have a physical copy of the exam to highlight and plan? No, it's really annoying. It's really annoying because you have to read it on your laptop and it's just like, yeah. And I don't even think you can highlight. Oh, no, you can highlight. You can highlight, but no. So bring a piece of paper if you want to plan it. You can write it down, but no. Is it a Word doc for the exam? Like, can you highlight the facts? Yeah. No, it's not on a Word doc. It's on a weird website that they've got. But no, I I actually can't remember if you can highlight the facts or not. I think you can. I think there's like a little pen that you can highlight with. Yeah. Do you know if you have to bring a hard copy ID? No, I think you can just have your Monash one, like your yeah, online. That's fine. Yeah. Cool. Any other questions? If not, feel free to hop out and good luck for the exam, guys. If you have any questions, you kind of email me as well. Just be mindful not too close to the exam because I do also have my own exams. So yeah, just give me a bit of time to answer the emails. Um, so I had a question from Jeffrey. Are we able to bring in notes in the form of one big notion or just a single Word doc? Yeah, you can have your notes like however you want. Doesn't really matter what website it's on or what. Well, and they need to be offline, but I use OneNotion and they're offline, so that's fine. Yeah. Um, yeah, that's fine. OneNotion is really good. Cool. All right, I'll end.